Let me introduce you to José Díaz Cuadras. He is the legal and compliance advisor. So he's a financial lawyer with a sound knowledge on banking, financial law, trading, and fintech, as well as corporate and compliance. He's a co-founder and director partner in Legal and Compliance Advisors, a firm of attorneys specialized in corporate government, financial regulation, and regulatory compliance, PLD and FT, and private equity, as well as new specialized financial products among other disciplines. So it's an honor to give you to José Díaz Cuadra.
Thank you, Vicky, and many thanks to Prosa for this invitation to this 2021 Prosa Forum. I really appreciate the opportunity to come to talk to you today about authorizations for institutions of financial technology. We couldn't talk about authorization of entities of this type if we don't first talk about the condition of the market. And for that purpose, it's important to provide some data which will allow us to see the importance of the fintech sector in the world and in Mexico, undoubtedly. 7 out of 10 Mexicans have no access to the services offered by banking institutions. In addition, 36.9% have at least one financial product. These are very low numbers, speaking of the need for financial inclusion, where we observe with 92% of people preferring to use cash. Now, the fintech sector has had an exponential growth, quite tangibly. 21,700 fintech companies exist in the world as of 2020. In Mexico, 441 businesses can be found on the radar, Sino Vista. Of these entities, there are 85 which requested authorization in the year 2019, and we have over 10 authorizations to date of entities that submitted this application. In 2020, the fintech sector in Latin America is the referent where $3 billion were captured for funding of operations of this type. Now, it's estimated that 60% of all young fintechs businesses that operate in Latin America were born between 2014 and 2016, but worldwide, 75 to 90% of these new fintechs do not manage to survive. And this is due to two main reasons. One, a poor conception of their business model from the numerical viewpoint, that is, the financial resources that they require to survive, which have not to do only with the business plan, but also with requirements for their operation by law. And we'll talk more about that later on. Now, what are we finding today in the fintech sector? Well, there's a new behavior of customers. Because of social networks, there has been an exponential growth in which the customer has three main characteristics. One, he's connected. Two, he compares. And three, he shares information. What does this mean? That his experience in reviewing a product often is better or greater than the experience of the person who actually has that product for sale because of the access that there is through social networks. Well, what happens in Mexico? Before coming to talk about Mexico, we need to understand that there are international items as a background regarding regulations in fintech matters. 4 countries can give us some very clear antecedents for this: UK, France, Spain, and Singapore, each with different directions. One used as a sandbox, as is the case of the United Kingdom, or in Spain with crowdfunding. We can remember what happened in Mexico when we think of those structural reforms in the National Development Plan 2013 to 2018, which had the objective of financial inclusion. This goal motivated or brought about the modification of various laws of the financial sector. In 2016, National Policy on Financial Inclusion created a specific chapter for the use of technological innovation, and a new law was created. We know it as the Fintech Law, the lay for regulation of financial technology institutions. Why was this law enacted? What is the reason for it? Well, there are many reasons which have to do with innovation and technology, but maybe the most important thing can be understood in 2 ways. First of all, the need for technological innovation to have a regulatory framework which will allow the mitigation of risk, but at the same time to allow the growth of the economy and the growth or expansion of the fintech business. And on the other hand, the innovations, the technological innovations themselves in the matter of financial services did not have regulation and supervision in the past. This created a need for including them in the regulated and supervised sector of the financial sector. So what does the fintech law regulate? Well, if we were talking about genre and species, we would say that it regulates the institutions of financial technology, and there are two. Each of them is known in three different ways. The first is wallets, and it also regulates crowdfunding. Wallets, also known in Mexico as electronic payment institutions, and crowdfunding, known as collective financing institutions, or the acronyms IFPs or IFCs. These institutions of financial technology are regulated, and also new or sandbox models, as they're known in other countries, open banking, and virtual assets or cryptocurrencies or crypto assets as they're known. Now, what was the objective of the fintech law? And this is very important to understand from the standpoint of what happened before the law came out. There were already players who were offering their services, and because of their activities, they qualified among the framework considered by the law. The objective of the fintech law is to regulate financial services lent by financial technology institutions, as well as three very important things: their organization, their operation, and their functioning. And in addition, it regulates financial services subject to some special legislation which are offered or carried out by innovative media. I want to stop here for a moment to talk about these three activities which come as a part of the objective of the fintech law. It says organize. I would start with function and operating, because it had never been seen in the financial sector that there were entities that were already operating before the law was enacted, and this was the exception. It means that there were entities that were operating before the law came out, and that the law recognized these activities, known today as the uh, uh, eighth transitory article, because in order to operate, you need to go through the organization in order to be organized and to function. That is not the case with the fintechs covered or considered under the eighth transitory article. Now, speaking of the authorizations of financial entities, who authorizes them? An organ that is known as an Interinstitutional Committee, which is made up of the Department of the Treasury, the Bank of Mexico, and the National Securities Exchange. Each of these entities represented by two members. Who presides over it? It's presided by the National Securities Exchange. And how do I get organized and how do I operate as a financial technology institution? Well, as we all know, the financial sector has laws and secondary regulations. The law of March 9th, 2018 established that different sections of secondary regulation would be established to express the law. The law is the what, and the secondary regulations are the how. I know that you are regulated as an IDF, but how are you going to do it? What should you show or submit to the Interinstitutional Commission to get authorization? Well, as I was saying, there's an enormous amount of regulation. This regulation, in one specific article of the law, establishes all the requirements for requesting authorization to create an ITF. And yet, it's not the only one. Let's go back to the date of the constitution of the law, March 9th, 2018. 6 months, 12 months, and 24 months were the three segments or sections in which the regulations, secondary regulations, were issued, which supplemented the law. And what did that mean? You'll remember in the entities which were qualified in the eighth transitory article, which recognized entities that already worked before the law was issued, and they needed to request authorization to be constituted as an ITF in either of the two modes. Well, the way that you will find that information compiled is in four very large columns. This has to do with the law, as I was saying. It's a specific article, but also the circular, which is most important. It was the single circular of the ITFs, and a large volume of secondary regulations, among them a guideline. This information that you see is the compilation in the column. Everything is regulatory. All of it is legal. Sometimes we say that the legal things have to do with lawyers. Well, not necessarily. Legal matters are the topic of lawyers, yes, but also administrators or engineers or consultants who provide services for entities that want to become ITFs. Well, in the first column, we have the lawyers or attorneys column, because there's information there that the entity must submit to in the matters of corporate governance and in statute projects when it's a new entity, or if it's an existing entity, the project of the assembly, which would modify the statutes to make them agree with the activities that the law regulates and which require authorization from the state for these purposes. Other information that is here, which is very interesting, is the three-layer information in matters of corporate governance. The first is owners, the shareholders. Then we have the administrators, which in this case, unlike the situation of other regulations for traditional entities, allows for a single administrator or a board of directors. And lastly, we have the officers or relevant personnel. Traditionally, there's a pyramid structure, and Fintech recognizes this for the purpose of information that is requested of these officers, but not so in the case of Fintech. In the case of Fintech, the relevant officers are those that exercise control over the entity, and those that exercise the control in the entity that exercises the control of the entity, or those who, as the law says, adopt measures which significantly transcend in four great spheres: legal, administrative, financial, and operational. What does this mean? That the person responsible or director or the person in charge of the legal, administrative, financial, and operational issues will have, along with the shareholders and along with the administrators, they will have to reveal information. It's somewhat different in certain partners and the percentages of those partners, but they all have to disclose information regarding their credit status. These are attachments to the regulations, which are statements made under an oath of telling the truth. These are suppliers that are sensitive. They manage databases, or they know the information of the management of databases. What is the trend of the platform? Where we go in to operate, where we go in to request, or as investors in the case of crowdfunding, who is the owner of that platform? It may be a licensing, I want to see the contract, or it may be a development made by the entity itself. I want to check and see how you accredit your ownership. That's what it is. We were talking about the attorney, the legal domain of the attorney. The next column, the business plan. This is interesting because it has a part which looks somewhat romantic, which is the mission, the vision, the reason for existing, along with who is the competitor for that entity and when it arrived at a break-even point, economically speaking. That is in income and in expense of the entity. And I still haven't gotten into finances. Within this business plan, there's also the corporate structure. Who is the owner of the entity? And if that entity owner is a corporation, who is the owner of that corporation? And if it's another entity, even operating abroad, who is it? Until we get right down to flesh and blood of the shareholders and disclose this, as we've already mentioned. Then we have the organic structure or organizational structure. That is, who directs the entity and who operates it. The CEO, those who are relevant officers, and those regulatory positions such as the compliance officer, the CISO, the head of security, information security, and auditors, and those who are specifically responsible for certain functions, taking care to segregate these functions. And lastly, the technological infrastructure, which is simply the function, the heart of these functions, and the peripheral, the ERP, the Treasury, the regulatory reports, the lists having to do with money laundering and so on. The next column, the numbers column, the viability, financial viability study, financial projections that are expressed in a conservative scenario, in an optimistic scenario, and in a fatalist scenario. And with stress each. For example, a situation of COVID, what happens to an entity during a pandemic and how does it survive? How will it live? When does it reach its break-even point? Next, and the last column, manuals. Manuals are not anything more than just the how of all the what that we've been discussing today. That is, there are operational manuals, the information safety manual, the manual of technology, the administration and finance manual, which has accounting, treasury, material resources, human capital, and so on. If we look at this great number, and you can see it in the information that we're sharing, this information specifically appears as to what is needed in these four great columns and where it is found and why it has to be done this way, the basis for it. In other words, why it exists, based on what law, what article of the law, and or a secondary regulation. And one of the most important things, speaking about the transitory 8th article, the periods for authorization. A while ago, we were talking about the fact that entities that were already in operation before the law came out, that is, that had activities which now fit the Fintech law, should request authorization, and the law recognizes this and allows them to continue operating, but they need to request authorization. And this is a very interesting topic from the point of view of the financial sector because it didn't exist. The Fintech law in the 8th transitory article recognizes them and allows them to operate, but they establish a period of time. The law is from March 9th, 2018. 6 months later, there is secondary regulations issued, specifically the single circular, and based at 1 year and 2 years after the law is issued, regular secondary regulation. I'll stop here on the regulation of September 2018 because it establishes the periods for which the applications should be resolved. And these time periods basically said from September 2018 on, 1 year afterward is the deadline for entities to request their authorization, whether they were operating under the 8th transitory article and therefore are allowed to continue operating, or whether they didn't operate before the law came out and therefore they need to wait for the approval of their request for authorization by the Interinstitutional Commission before they can operate. Those time periods, based on the time at which the authorization was submitted, if everything occurred practically in reality, in September 2019, the National Banking Exchange Commission comes to the Interinstitutional Committee and they dialogue on the authorization for 6 months. That's the time frame for resolution of the authorization. However, because of the effects of the pandemic, those periods were completely different. It was necessary to provide extensions. And within this time period, the law recognizes that within 90 days from those 6 months, this was the period for requesting authorizations. Well, what happened in reality for several of the financial entities, that is ITFs, because let's remember that the ITFs are now financial entities. They come into the financial sector as financial entities. So what the regulator does is try to recognize the greatest number of possible elements to proceed to the authorization. Within these time periods, once again, there are specific periods that you can see for receiving the information, to submit observations or remarks on them, how much time we have, and what is next. This is the first time that we have in the financial sector a situation where, in the case of a lack of information regarding the regulator as to whether it was approved or not, it's considered negative ficta, that is non-authorized. That's part of what's in the regulations. And lastly, and maybe within the most important things, we find that financial entities that are new through technologies such as our case, now have the great challenge of providing financial inclusion being profitable. And this can only be seen definitely from their own delivery of information and on time. We will later see what happens with financial entities over the next few months and years and see how far we can go in actually achieving an effective financial inclusion. I'm grateful to Prosa for the invitation to this 2021 edition of the Foro Prosa, and we'll go on now to a time of questions and answers, and I would be glad to listen to questions and respond. Thank you.
Muy bien, bueno, pues de las preguntas que hemos
Okay, so out of the questions that we have received from you, let me read some of them and I'm going to address them. So the first question is, how many fintechs are expected to be participating in the Mexican financial system? So this is a very interesting question because it depends on the times. If we were to see how many were requested from the creation of the law, there were 100 requested. The resolution of the request has been addressed by the Institutional Committee from the Bank of Mexico, from the Ministry of Finance, and the National Banking and Securities Commission. Most of the authorizations have been addressed. Some of them have been already posted or published in the official gazette, and some of them are still subjected to a suspended condition, which means that because of the term that has elapsed, and as I mentioned earlier, that because of the pandemic, mainly, the terms have been delayed. So what happened? There are a lot of fintech entities, practically all of them, that have a funding, whether it's from shareholders with some conditions that they statutory establish, or from venture capitals or private capital funds that have some conditions in order to go with convertible notes. Just to give you an example, what does this mean in Spanish? Well, that these are some corporate agreements so that after certain events or a certain time, the people who were funding the constitution of the society will be the shareholders once the approval is in or certain months have elapsed. And let's remember that it's been since 2018 that the law was issued, that there are still some approvals being analyzed. So this makes that there are some entities that because of this corporate commitments or specific events, they have to turn those shareholders. So the authority said the time you established has elapsed, so you need to convert. So that's one of the many suspensive conditions there may be. So the big moment is the ones that have been requested. As I mentioned, we have over 10 that have been already approved, and a lot of them are about to be solved in this suspension and pending to be approved. Now, recently, within these terms that have elapsed from last year until now, they are still interested in requesting or placing requests for wallet or crowdfunding. So it's a huge number. So I think there may be about 150 entities in the process for approval. Now let's think that probably in 1 year we'll see how they start operating and what are the business models each of them have and the market they're tackling. Now, the following question we have is the legal environment appropriate for the fintech market? My answer is yes. There are a lot of questions regarding the regulation being excessive or not. But let's remember something important. They're using money, let's not say public or savings money, but if it's public, this is from third parties. So they're handling the money, they're capturing the money, and I'm gonna mention both of them, IFCs and IFPs. IFPs are actually collecting money in order to issue or transfer funds from electronic payment. which is basically a virtual account, and the law can see that this is associated to transactional accounts. Therefore, it's very important to understand that the legal term and the legal requirements for the approval must be as solvent as any financial entity. And the last question is, so are the problem resolution terms being respected? This is a complex question. No, because of the pandemic. Fintech entities should have been approved practically over a year and a half ago. However, the effects of the pandemic substantially modified the terms in such a way that the main request done had several rounds of reviews from all the applicants or towards all the applicants. And finally, the reviewing terms of the regulator were also moved because of the same reason. So I think that beyond talking about respecting, this is being respected based on a responsible analysis from the regulator. Okay. I want to thank you all. I'm here for you. And once again, I want to thank Foro Prosa for having me.
Thank you so much, Jose. Jose Diaz, thank you so much for joining us, and thank you for answering all the questions from our audience.